to define Order 32 Rules of High Court 2012, where every application in chamber shall be made by notice of application in Form 57. An application to the court must, whether it's High Court or subordinate court, must be made by Form 57. Order 1A mentioned that in administering this rule, court shall have regards to the overriding interest of justice.
The applicant herein was joined as third party in this case on 25 February 2019. Upon statement of claim being served upon them, they had 14 days to file and serve a statement of defense as third party in session court. The applicant failed to serve their statement of defense within 14 days as required on the terms order. The respondent filed an application dated on 10 July 2019 to set aside the said statement of defense for the application failure to abide the terms order. The applicant also belatedly filed an application for extension of time to file their defense. The session court set aside the applicant's statement of defense and dismissed their application for the extension of time. Thus applicant filed and served a notice of appeal on 2 August 2019 against above order, which was itself out of time by 8 days, where it ought to be filed on 25 July 2019. The case management were fixed on 2 September 2019, where the applicant and counsel failed to appear. As a result, the application was struck out on that day. That applicant caused instant originating summon to be filed, which was heard on 3 December 2019 by stated this filing was purpose for extension time to file notice of appeal dated 1 August 2019.
The issue is whether the Replit Industrie Sendirian Berhad application to extend the time to file their notice of appeal against NZBina Sendirian Berhad date 1 August 2019 was indubitably filed. Order 3 Rule 5 extension may be granted by the court by taking into consideration of this following factors: firstly, the length of the delay; second, the reason of the delay; thirdly, the chances for the appeal to succeed; fourthly, the degree of prejudice to the respondent. The applicant notice of appeal was late 33 days from the date of 25 July 2019. Despite the delay, it has been found reasonably explained. However, there is an absence of satisfactory explanation. The reason for the notice failed to be filed. The explanation provided is untenable by law as its conflicts of administration nature. The applicant ground for such delay as they are not aware of the said date. Therefore, not aware is not a satisfactory explanation, but it's just a mere excuses. Failure to file statement of defense in time, not just merely breach of an order, but it is considered as clear contempt of court. Applicant excuse for the reason to file the statement of defense due to their solicitor neglected his duty is unacceptable and clearly unreasonable. The result of delay will only cause unnecessary cost and time to be wasted, not only to the respondent but also to the complainant in the action. Court taking into consideration by granting application to filing notice will only taking much longer time for the trial.
Find out the applicant has barely sufficient ground to bought with their application to buy the time for the intended appeal filing. Their defensive action potential prejudice does not suffice the requirements needed. The court found that the applicant was not using the correct mode for the application pursuant to Rule of High Court 2012. Any notice of application must be supported by an affidavit, as their application is not a new suit to used originating summon. Order 32 Rules of Court 2012 states all modes of application are now by notice of application and not by summon in chambers. Affidavit in reply must be served 14 days from the service of sealed copy of application. The applicant was also failed to insert the entitlement that cites the relevant section for contentions which could shock or embarrass the respondents.
The non-attendance of both applicant and solicitor. They could not manage for the chance to restore the appeal prior to filing the originating summon. The applicant barely had any reason to extend the ample time for their appeal filing. In conclusion, the applicant failed to convince the court for their application to be granted, as they fails to follow the modes, and their action has caused delays in proceeding which resulted by breaching court order.